Okay, my name is Gary Brimley, and we are going to next talk on adjudication of water rights. So, what is an adjudication? Adjudication, in its broadest sense, the word adjudication is an action that determines rights among various parties, and it's a judicial process. So it is a process that goes through a court before a judge to make a determination of parties' relative rights, or to make a determination between the parties to the action. And in the sense of water rights, a general stream adjudication is an action that joins all the water users on a source, and including the state and federal agencies, and it joins the state engineer, which the Division of Water Rights. And it is governed by Utah Code Title 73 and Chapter 4, and this sentence is different than what's in your book. So it is an action to determine the nature and extent of all existing water rights within each river drainage. And then the part that's changed here is your book says that the first general stream adjudications were done on the Sevier and Weber rivers in the 1920s. The rest of the state is still ongoing, and frankly, the whole state has either been through or is going through general stream adjudication. So why we conduct general adjudications? One, to bring all claims to the use of water onto the permanent record. So there are existing claims out there, diligence claims, or water rights that were initiated prior to the adoption of water law governing the use of water. And if a water right was started prior to the adoption of water law, then that is a pre-statutory right. And there may or may not be record of that water right. It may just be something that floats out there without any written record of it, but people respect it. Maybe the person that owns that water right exercises it, and the people in the vicinity, the neighbors, they respect it, and they are okay with him using it because it's a pre-statutory right. But in order to bring it onto the record, we conduct general stream adjudications, and those claimants are required to file those claims. So in the case of surface waters, they're called diligence claims, and in the case of underground waters, they would be called underground water claims. And the two dates here are the dates when those water law, those statutes were adopted and put into effect. So those claims may have been off of the record all the way up until the general adjudication brings them on the record. So it's a very long time that they've not been on the record. And also to bring Federal Reserve rights onto the record. And in order to do that, we join the federal government, and they are required to participate in the action according to the federal laws that are in place. One of them is a case law called the Winters Doctrine, where I think it was, I can't remember which reservation, but a reservation somewhere in Montana, the federal reservation for Indians in Montana was lacking water, and the state had already appropriated a lot of water rights on the river system that ran through there, and the Indians approached the state and said, okay, we need to use our water, and the state told them no, and so it went to court. And the judgment in that case was that when the reservation was created, there was an implied reserved water right that it didn't have to be stated, it didn't have to be written, it was implied that the reservation would have enough water to serve its purposes for in this particular, in the case of this Indian reservation, and I think in most cases for Indian reservations, that the purposes are that they can use the water for whatever amount of water that they need to sustain their an assumed lifestyle. I think an agrarian lifestyle. But anyway, the McCarran Amendment on here, the 1952 law, was promulgated by a senator from Nevada in 1952 to require the federal government to participate in general adjudications. This is kind of unique because usually you can't sue the federal government unless they let you, and the venue for that is usually a federal court, but this law brings the federal government into our state district courts for this process, for the general adjudications. So they must participate and settle their claims. And this is good because we want to have a clarity, we want to know what their claims are so that we can have some order and certainty in administering and distributing the waters of the state of Utah. Number two, it's to prevent a multiplicity of suits where various limited numbers of parties would be joined. We don't want, one party suing another party and then in a separate action, another separate action between limited parties, and then multiplicity of these suits going on to try and determine limited scope of relative water rights amongst these limited parties. We want to join everybody to get it all done at once so that we have a clear picture of how the waters from a river system should be allocated. 3, to remove and reduce rights which have been wholly or partially forfeited through non-use. And so as we adjudicate, as we perform our efforts, we investigate rights and make a determination as to what rights are continuing in use to this day. And if rights have gone into non-use for the statutory period of 7 years, we recommend to the court that they be declared forfeited, and that's a judicial action. The state engineer doesn't cause the forfeiture action or doesn't make the declaration. It's a judge that makes that declaration. And to obtain final comprehensive decrees on all water rights within the respective drainage. So that is kind of the end goal here, is to get a picture of how the water rights operate and cooperate in each respective drainage. So here's I'm going to go into where we are at in our adjudication efforts. Maybe this slide, next time I do this presentation, I'll put this slide toward the end after we tell you more about how adjudication works. But anyway, right now we're currently adjudicating within the Utah Lake and Jordan River drainage. So back on that second slide, you had the picture of Utah, and it was divided up into the river basins of the state. And the Utah Lake and Jordan River is one of those large basins. It's quite large. It includes and involves the Utah Lake, and it involves the Provo River, and right here up on the screen it involves the Jordan River and all of the tributaries up on the canyons on both sides of the valley here. In several decades ago, we already completed adjudication of the west side of the valley, and currently we're working on the east side of the valley. So you'll notice that the west side of the valley is broken up. Here, I'll show it to you a little larger. Broken up into some areas that we call subdivisions. And those 59 area subdivisions have proposed determination books published on them, which is the gray depiction right here, PD previously published. So that proposed determination is a proposal to the court that the rights be determined as they are written or as they're published in that book. And we also have up in toward the eastern and northern parts, which is really closer to Salt Lake City, There are some PDs also published and a couple decreed, or a few decreed, and this just demonstrates the current progress or where we're at on this adjudication. So I wanted to talk about why the east side of the valley has been chopped up into such small subdivisions, and that is due to recent events in our legislature that have allowed a ramping up or a speeding up of the adjudication process, or facilitating it to get it done. SB 75 from 2016 was the biggest change that we've had in the adjudication for many decades, and that is the publication of a list of unclaimed rights. So in the statute, when an adjudication is ongoing, water users are required to file claims. And the failure to file a claim, according to this new statute, if the claim doesn't get filed, it gets the water right number, or the water right, gets published on a list of unclaimed rights. So that list of unclaimed rights is submitted to the court, and we'll talk about it a little bit later, but the list of unclaimed rights kind of forecloses the opportunity to file further claims in the process. You have to do it when you are given your legal notice that you must file a claim, and if you fail to do it, you go on the list of unclaimed rights. And that was SB 75. And then the other two on here, 2018 and 2019, these statutes affected the way that summons is done in adjudication. It's not super critical that I go over it right now, but they are more demonstration that the revisions to statute lately have helped us speed up the adjudication. And we've had a couple of other things on this slide that I'm not really concerned in going over. A special master and some statistics on how much work we've been able to accomplish over the last couple of years. And this second picture is showing you where we're intending to proceed onward to later this year. So this year we're going to be commencing work in several subdivisions throughout Utah County and Wasatch County. This is still the Utah Lake and Jordan River drainage, and this is on the Provo River division. So the Provo River runs through this, and we're headed into Lehigh and Provo City south and north, the Provo Canyon, and up into the Heber Valley, and then above it to the Camas Valley. So these subdivisions, we will start giving people notice that the adjudication is occurring, and then that will lead into the time to file claims and the cutoff to file claims and so forth. So where adjudication begins. So I have a slide that shows kind of the critical elements of our process from beginning to end. It's in kind of three parts: the beginning, the middle, and the end. Right now I'm going to tell you about all of these elements, and there's a lot on this slide, so I'm going to just limit it to the first part after I get through this, and after I get through this particular part. So HB 355 this year moved the location of our, or the timeline or the sequence of events for our final summons. It moved the final summons up to the list of unclaimed rights, which we talked about. So those statutory recent changes started the list of unclaimed rights process, and in order to kind of wrap up the time to file claims in the adjudication, the final summons is required to happen now after the claims filing process wraps up, at which point we can put a button on that list of unclaimed rights and get a decree out of that list of unclaimed rights, which forecloses the opportunity to file any further unknown claims. So Now that I've shown you the difference on my slide, I prepared this slide after the book had already been published, so you can see that this is different than what's in your book. This final summons is going to stay right here between 8 and 9. So the adjudication process begins with the commencement of an action, where an action is filed in state district court by a petition, whether it's filed by the state engineer or the water users. And as I already mentioned, these are already ongoing throughout the whole state. So the petitions were filed many years ago. And in the case of, for instance, the place where we've focused our efforts recently, the Utah Lake and Jordan River adjudication began in 1944. So this step number 1 began about 75 or 80 years ago. Step number 2, a notice is published in the newspaper to give notice to everybody, all potential parties, that this is ongoing. This is an action that is happening in the court. And the reason it's in the newspaper is that we want to be able to give coverage, make sure that it reaches the public. And so that's what the word publication has to do with. And then a summons is mailed out to the potential parties. And we are currently mailing out summonses to all property owners, and we hold a public meeting. So let's see here. Sorry. All right, that didn't work. There we go. There you go. In case you wanted to see that animation again, the final summons has moved up between 8 and 9. There we go. That is not what I wanted it to do. Numlock. There we go. Numlock was off. So the public meeting, the state law requires the state engineer to hold a public meeting, and that's simply an opportunity for the public to come and learn more about the adjudication process. And then we move on to picture number 5, or portion number 5 here, the notice to file claims within 90 days. So that notice is sent out or mailed out to all property owners, and the reason we do all property owners is that we're trying to reach all potential water right holders, and the state engineer is not informed of everybody that has a non-existent or a non-filed water claim, a claim that is not of record. Those claims could exist, people could be respecting them again, like I've already mentioned, and we don't know about them. So in order to capture all of those potential claims, we mail out notice now to all property owners and publish it in the local newspaper. And for those who already have a claim of record, because there are plenty, there's plenty of claims that are already on record, a file room full of them upstairs. We have a pre-filled computer-generated form that it gets mailed out. And for those who are just the property owners that we don't already know if they have a claim, they get a blank or a water user's claim with a bunch of blank lines so that they can fill that out. And they fill it out and they can file it. The claimants can complete their claim, and they have 90 days to do that. And they can file it with the district court if they want. It's probably easier to file it with the state engineer. And the state engineer will then compile the claims and file them with the district court. They may also request an extension of time to complete their claims. In the most part, the claims that are already on record, the water users should sign and file and then that indicates, so if they sign and file their claim, that indicates that they are interested, they're participating in this process, they are indicating that they're using the water and that they're claiming that water right. If they have to fill it out, we're willing to help claimants fill it out. Then, and here's a closer up example of what a claim form generated from our computer system would look like. It's printed up with the claimant's name and some specific information about the water right. where it's used and how it's used. So there's source information and there's nature of use information. And then there's the explanatory section that you can write on, and you can attach any attachments to your claim, and you sign it and file it. At this point, we don't require any more notarization. A claimant doesn't have to have their claim form notarized. It's merely the action of signing and filing it with with what's called an unsworn declaration, and that is acceptable to the court for the court process. So our staff might help the water user in completing the claim, and we will compile and file all the claims at the district court on behalf of the water users. And this is a critical thing that we get a lot of questions on. People that have applications that are in process of appropriation, they have proof yet due that haven't been perfected. Do I have to file a claim on that? And the answer is no. We're looking to compile claims on perfected rights only, which are rights that were appropriated and have received a certificate of beneficial use, or those diligence claims, the pre-statutory rights or decreed rights, which is interesting because in a lot of cases, those limited party suits from years past have resulted in decrees adjudicating single rivers within the drainage. So there is, for instance, in the Utah Lake and Jordan River, there's the Parley's Creek Decree, and the Little Cottonwood Decree, and the Big Cottonwood Decree, and the Mill Creek Decree, and there's also the Provo Decree, and so many others that are simply or merely on that one river, but they're not within the whole entire watershed. And so those rights that arise out of those decrees, or that are recognized through those decrees, they come through and they are placed into the general adjudication process in order to obtain the comprehensive decree on the drainage. All entities, including individuals, companies, and municipalities that own a water right in the adjudication area should file. And something not written right there, but inferable, is that shareholders aren't exactly the ones that should be participating in respect of their shares. Of course, if they're an individual and hold a separate water right, they should participate. But for shareholders, what they should do is closely follow the company and ensure that the company is participating. So as a shareholder, I would ensure that the leadership of my company has filed claims, and if the company hasn't done that, I would be on their case to get that done. And then another frequently asked question is, well, what if my company simply insists on not participating, or is simply obstinate and doesn't participate? Then a shareholder can also file a claim and claim that the water right is in use as a claimant, but not as an owner. So the claimant, shareholder, can file their claim and participate that way. And for claimant claims that are not owner's claims, we'll put those claims on, we'll associate those claims with the appropriate water right file and place those claims on the respective water right file that those claims are filed for. And then moving on to number 6 and 7 right here. This is where I was going to tell you there's more information about the list of unclaimed rights. The list of unclaimed rights, let's see. Here we are. The list of unclaimed rights is a publication that we submit to the court. It lists in sequence the water right numbers from that subdivision that are included in that list for failure to file, having filed a claim. So if a claim is not filed, it's an unclaimed right, and if it's unclaimed, it goes on this list, and then we publish it, and a public meeting is held, and people have 90 days to file an objection with the court. So if you're inspecting the list of unclaimed rights and you see your water right listed on that list, it's not, it's not necessarily a good thing. You don't necessarily want to lose your water right. And so you object and you say, hey, wait, I meant to file a claim, and here's my claim, and with your objection you attach your claim as an exhibit, and you have to provide an excuse to the court, a reason that you failed to file in the first place. And then we go through objection resolution. So the state engineer may choose to simply admit or allow that claim to come in late, and there must be some reason for it, and then the court says, yes, that's fine, and it strikes that water right off of the list of unclaimed rights. Or, of course, there is the possibility that it doesn't get resolved in that way and that the water right remains on the list of unclaimed rights. I would hazard a guess that it's more likely that we would settle for, or we would allow, or the court would allow the water right to be removed from the list of unclaimed rights is in most cases the likelier answer. Okay, and then this is where, between 7 and 8 on this slide, is where the final summons would happen. So the final summons gets published in the newspaper, and people have that last chance to join the process and file their claim before a judicial decree is entered on that list. And a judicial decree on the list of unclaimed rights would do a couple of things here. It would declare or render a judgment that the rights on the LUR, the list of unclaimed rights, are abandoned. And the second thing that it would do is prohibit future diligence claims from being filed. So prohibiting the filing of future claims to rights that weren't previously on record. So, rights not of record, they are foreclosed after this process completes, after the list of unclaimed rights has a decree. And that is an interlocutory decree, which word interlocutory only means that it's kind of partial, or it's partway through the process. It's not a final decree, but it is final as to the aspects that it is adjudicating. So it's final as to the list of unclaimed rights. It says that is the last time for people to file claims. It's just not final in the broad sense of the general adjudication, because that is not over yet. And then we can move on. So number 10 on this slide is the claims investigation process. And that process, I already talked about the claims. So the investigation is this red one down in the bottom right. Water users' claims that are filed, and this is the important part, or the reason that this is the part of the process that creates a permanent record for the state engineer's records. We do investigation and mapping. So we produce a set of maps called a hydrographic survey map, and that hydrographic survey map set depicts all of the places that irrigation rights are used, and it depicts all of the points of diversion that water is taken from, whether they be wells or springs or streams and so forth, and that's part of our investigation of the claims. We inspect them and see that we do field work and go out to see that they are in use. We generally take pictures. We memorialize for the water right file record where the water right is located, with typically with GPS. And then number 11, we prepare a proposed determination and hydrographic survey map set. So the proposed determination is, let's see if I can just get to the next slide here, the book that describes all of the water rights and their characteristics. So in a proposed determination, it lists the owner of record. So the owner of record may not necessarily be that claimant. So a claimant could file a claimant claim, or a shareholder could claim that they are using the company water rights, and the owner of record in that case would be the company. Or the owner of record, in case title hasn't been updated, it may be old information from an appropriation or from a decree award or from an old diligence claim already on record, the old owner's name may still be listed if title hasn't been updated. And it explains the interest in the water right, the type of right, the flow rates, which are important aspects, whether it's a flow rate in cubic feet per second or the acre-foot volume of water used, or both. And it is something that we may do, is we may put both on a water right. The source of water, whether it's the surface and the surface source name, whether it's a named spring or a named stream, or whether it's an underground water well or whatever other source, and the point of diversion location using the public land survey description relative to section corners. The beneficial use information, these are all characteristics of a water right that you've already learned on yesterday's training, but these are all the things that will go into a PD. So of course, and any other, the place of use, the nature of use, and any other limitation information and commentary if there be any. So explanatory remarks. And it is filed with the district court and distributed to water users. So today's distribution method is by sending out a one-page notice telling water users that they may obtain copies of the proposed determination online or at our offices or at the district court, since it's on file with both our office and the district court. And we hold a public meeting to discuss the particulars about the proposed determination and answer any questions about the process. This is what a hydrographic survey maps page would look like, and in particular there's some elements about it. It's just a snapshot in time. Today, or as we investigated the water right, it was being used on the lands depicted here in these polygons, the red, the green, the blue. Next year it might be different. So it is just a snapshot in time. It only gets to be different if there is the legal aspects of that are that a person can file a change application to change it, or if it's shares being used within the service area of a company, the service area is an allowance or allowable area where that water could be used. The hard copy of the hydrographic survey maps is on file, but we also upload it to the internet, and they can be obtained in PDF, portable document format. So we hold a public meeting and we go through objection resolution. After we do objection well, actually I should say a word or two about resolving objections. So the resolving of objections is again a court process. In the case of some areas, we may have a special master. And the special master is a court-appointed person who interfaces with the court and works with the judge. So they are court-appointed. They're not state engineer. The special master keeps the wheels turning. He's the grease in the objection resolution process, where a person who files an objection, if they don't like the way that we published the proposed determination, or if there's something about the field investigation that is wrong, they would object and say, hey, my water right has 1.5 CFS instead of 1, or it's used for 18 acres, you missed 2.5 acres, something like that. Or, I'm the owner of the water right, you listed so-and-so as the owner, but I can show that I'm the owner, and then through that objection resolution process they would provide their documents and their evidence, and we would have that, that process would resolve. And after that happens, we try to get a decree. So in the early days, like back in the 1920s, the Sevier and the Weber, as we talked about earlier, they would have one proposed determination on the whole entire river drainage. Maybe it was feasible back then. We don't feel like that's so as feasible now with the population having grown as it has. So we subdivide we divide the general adjudication areas into divisions and subdivisions, and That's why we work in bite-sized pieces in order to get the process done now. An interlocutory or a partial decree is often issued for the subdivisions nowadays. Federal reserved water rights might be omitted from the interlocutory decree due to ongoing negotiations or even the lack of federal joinder. So the state engineer actually has to serve the summons on the federal government, and there are places that we have not yet done that. Decrees often include language closing the respective basin from additional diligence claims. As we've changed the statute, we've gotten changes in the statute recently. That closure comes through the decree on list of unclaimed rights. And I just want to go through some frequently asked questions. So what if a water user chooses not to participate? Any rights not claimed may be declared abandoned, and that person or that person who doesn't participate or file a claim no longer has a right to appeal if they don't participate from the get-go. So they no longer have a right to appeal or object to the proposed determination. What if my water right is listed in the name of a previous owner? The title updating process is separate from adjudication. You should file a claim as a claimant to protect your water right from being declared abandoned. So if you say, oh yeah, well I got my water right from Grandpa, and Grandpa is on, his name is on the records of the state engineer, and the proposed determination gets published in his name, then later you can update title to your water right. So even if the proposed determination is published and filed with the court in a previous owner's name, that doesn't foreclose you from filing a report of conveyance and showing the deeds that bring the water right into your name. What does it mean if the status of a water right says disallowed? So that's a designation that we use to indicate to the court that there could be one of two reasons. The following two reasons are that it might be disallowed based on evidence of non-use, which is to say forfeiture, and that we are recommending the water right be declared forfeited. Or it may be that the claim is an invalid claim. So somebody just, doesn't really have a water right, but they submit a claim and they say, yeah, I use, 800 cubic feet per second out of such a river, and I use it for these 30,000 acres over here. It may be an invalid claim, and we might recommend that to the court to be declared invalid, having no legal basis. And grand juries are typically not a part of the adjudication process. That brings me up to the end of this presentation. So who can I contact to discuss adjudications? My supervisor, Blake Brigham, is the program manager, the assistant state engineer over adjudication. I am the engineer manager, and our general info is right there on the slide. Do you have any questions? Yes, sir.
All right, I have a couple questions here. One little frustration. That last thing said that water rights listed the names of previous owners. Are those on your frequently asked questions on the website? Because that's the one that applies most to me, and of course it's not in the book. So I'm trying to write it down off the screen.
Yeah, I did make modifications to the presentation after the book was printed, so sorry.
But is that on the website?
There's a lot of information about updating title and that type of stuff. I don't know if this particular question and answer are anywhere in our adjudication section of our website, but there is a lot of information about this stuff.
And I'm sure you'll put it on there since you're being asked to do so.
Yeah, I can certainly consider putting it on our website.
Thanks, sir. The other question I have is, you talked about the final summons being published in a newspaper.
Certainly.
Now, is that the only place it's published, or do you also send out to known participants a final summons, or do they have to watch the newspaper?
Very good question. Very good question. So actually, the final summons purpose, and I certainly want to make sure that we're clear on that there are two summonses in this process. There's the initial summons and the final summons. The initial summons is published in the newspaper and sent out mailed out to people. Again, the intent of publishing anything in the newspaper is to get the information out to unknown parties, the public. And so in the case of the final summons, and to directly answer the question, a final summons is not sent out to known parties because they already got one summons, and one summons is enough in this case and in any case as well as the general adjudication case. One summons is enough. The purpose of the final summons is that the statute requires it, A, and so B, it's only published in a newspaper to finally join any unknown parties who didn't, and this is the clincher, it actually says in the statute, it says in the summons, joins any parties who didn't get notice by any other way or any other means. So it's only published in the newspaper.
Thank you.
Any other? Yes, sir.
How do you get a copy of the, how do you get a copy of the historical decrees, say Weber River decree?
That's a good question. So I think that's worthy of showing you on our website that there's an adjudication section on our water rights website. And so if I'm at our homepage here, I could go right down to this link to the adjudication. Also, it's under programs adjudication. So you'd certainly want to hit that link. It takes you to here, active adjudications and so forth. A lot of information is compiled here. And the answer to your question is that there's a space for decrees. So you would go to the decrees, and this is a landing page, the splash page. It doesn't have all the decrees on it. It has some important case law and some important decrees. But then where you want to go is into where we have all of the decrees by county. And this is a listing of so many decrees, so many historical decrees, such as, you know, if I go down to Salt Lake County, there we are, that's Salt Lake County. As I was mentioning, we have Little Cottonwood, Parley's, Mill, Big Cottonwood, and then a lot of other little things here that are just interspersed. But these are the early 19-teens, those individual rivers were adjudicated. And same with a lot of other rivers in the state. A lot of adjudication work or a lot of limited scope actions occurred on many individual river systems in the early 1900s. Any more questions? Well, thank you very much. I guess it might be worth, if I could, one more thing, just showing a little bit more on our website, and I'll just take maybe a minute to show that our adjudication page has kind of some information in a 4.5-minute video on basically what I have really gone into detail on today. Active adjudications are listed here so that you can access lists of the water rights that are in the most active areas where we have sent out summonses and notice to file claims. So these 57 area subdivisions, they've all been commenced last year, and we are currently working through claims that have been filed in all of these subdivisions. The 55 area, 55-4, just commenced this past January. And so if you went to one of these subdivisions, it lists the water rights that, and let that resolve, the water rights, the page has to load for a second. And it just gives you kind of a picture of where we're at in the process. So this is filter claims by progress. After this page hasn't fully loaded yet, but you can choose, you know, you can toggle these checkboxes and you can see the various water right claims or the various water rights by number that are located and being adjudicated in the active subdivision. So it's a lengthy list and just demonstrates how you can access some adjudication information. Thanks.